5.
Thank you, Lachlan Corla. Minister, this question arises from reports in recent weeks that the IBRC and Anglo-Irish Bank, as it was previously known, compiled lists of politically exposed persons and high-profile persons who were borrowers from the banks. And the question just seeks to find out is why the bank felt these lists were necessary, what knowledge the Department of Finance and yourself as Minister had of them, and what were these lists actually used for.
Minister number 5.
Thank you very much, Deputy, for your question. I am advised that Anglo-Irish Bank, IBRC Limited and IBRC Limited in special liquidation has a legal obligation under the Criminal Justice Act 2010, that's CJ 2010, to determine whether or not a customer or a beneficial owner connected with the customer or service concerned, being a customer or beneficial owner residing in a place outside the state, is a politically exposed person or an immediate family member or a close associate of a politically exposed person, known as a PEP. According to the Criminal Justice Act 2010, a PEP is defined as an individual who is or has at any time in the preceding 12 months been entrusted with a prominent public function, including either of the following individuals, but not including any middle-ranking or more junior official. And 1, a specified official. 2, a member of the administrative, management or supervisory body of a state-owned enterprise. The Criminal Justice Act 2010 requires that institutions take the following steps prior to establishing a business relationship with a customer or carrying out a transaction. 1, have appropriate procedures in place to determine whether a customer or beneficial owner is a PEP. Enhanced due diligence procedures are required. 2, obtain senior management approval prior to the establishment of a business relationship with such a person. And 3, ensure adequate measures are taken to establish the source of wealth and the source of funds involved in the business relationship or occasional transaction. In addition to this, in line with good practice and anticipation of future legal developments and our media coverage, including recommendations made further to the Mahon Tribunal, banks typically maintained a list of domestic and high-profile customers and borrowers with significant prominence in the public domain due to, for example, business, sporting and media interests. The special liquidators understand that customers, borrowers of IBRC Limited, that is the special liquidation, were included on such a list in accordance with the provisions outlined above. The inclusion of customers on these lists was standard business practice and in no way indicates that preferential treatment was afforded to these customers.
I should interrupt the Minister there. The rest of the reply will appear in the official report. Deputy Pringle.
Thank you.
1 minute.
Okay, I take it from your response, Minister, you're saying that these lists were compiled in response to the 2010 Act. When were the lists actually compiled in response to that? And also, how do we know and what assurances can we have that these politically exposed persons or high-profile persons didn't receive any preferential treatment in dealing with their accounts within this institution? And I think it's vitally important that people can be reassured that by the fact that these lists were not compiled in order to ensure that people, or to identify people who could receive preferential treatment, and I think that needs reassurance.
Thank you, Deputy. Minister.
Yeah, the lists were compiled certainly before the liquidation took place, but I haven't got the exact date. But it was, compiled by Anglo-Irish Bank and then IBRC prior to the liquidation occurring. It's part of the process of the liquidation to ensure that nothing untoward happened. And if the liquidator comes across anything that could be deemed as a criminal offence, he has an obligation to report that to the Garda Síochána. And so far, the special liquidator assures me that he hasn't come across anything which would amount to malpractice or anything like that. But his study of those issues is ongoing. But I wouldn't be the person he would report to. But in conversation with him about the process of the liquidation, these things come up. But I mean, the main point is that this wasn't an initiative taken by IBRC to list their well-known people for any other purpose than complying with the Criminal Justice Act 2010. So that it's to do the opposite of what you suggest, to avoid preferential treatment being given to people because of their place in society, because they were important in a state agency, or because they had political power.
Thank you, Minister. Deputy Pringle.
Thank you, Laskin Well, the one thing about politically exposed persons is that the political exposure could be used in different ways. And there is some high-profile people on that who appear to be on the list who have had debt write-downs from the IBRC, and there is other people then who have been taken through the full remit of the courts and the law and been bankrupted as part of that. So I think we need to be assured that these lists were only complying with, as you say, the Criminal Justice Act 2010, and that no preferential treatment was given to anybody on these lists. And I think it's incumbent on yourself, Minister, to ensure that that is the case. And I would like maybe if you could inform me of the date as to when these lists were compiled as well.
Thank you. Final reply, Minister.
Yeah, I mean, I think I've dealt with the issue. I think a lot of people, a lot of the public would find it surprising that this provision is in the 2010 Criminal Justice Act. But when you think about it, it's a pretty good provision. And I hope it's being honoured right across the banking system. I'll get you that date and I'll communicate in writing to you.